I'm grateful to everyone who's joining us today, whether it's your first time with Berkeley Judicial Institute or one of many. We're really grateful that you're spending your time with us. Today's program is the third in our series on judges in the press. And today we're going to talk about how judges should communicate with the press when a case is proceeding. Please keep an eye on the chat. There you will find more about Berkeley Judicial Institute, more about our spectacular faculty, more about applying for continuing legal education program, for continuing legal education credit. Even more important for the participants, that's where you can post your questions, your comments, your concerns. The chat has been really active in the past two programs. We've taken the good tips that we've received from the chat, sort of anonymized them, taken names off the chat comments, and have posted those to the Berkeley Judicial Institute site. So keep the chat coming. We appreciate your comments. So as I said, we have a spectacular faculty assembled to lead this conversation, and they've forgiven me for the world's quickest introductions. They are our moderator, Judge Bernice Donald, recently retired from the Sixth Circuit Court of Appeals. By video, Judge Jeremy Fogel will join us at the end of the program to wrap the program up and to make some thank you comments. He is a retired district judge from the Northern District of California and is Berkeley Judicial Institute's executive director. Charles Hall is a public affairs specialist and at the administrative office of the U.S. courts and is a former reporter. Judge Marcia Krieger is district judge from the District of Colorado, and Dan Levine is a correspondent for Reuters. While we're so grateful to all of our faculty, we have to specially acknowledge Judge Krieger and Charles Hall, who developed a similar program for a group of judges earlier this year. BJI has borrowed with permission and attribution from the program. We're also proud to have such great co-sponsors, and they are the American Judges Association, the Federal Judges Association, the Federal Magistrate Judges Association, the First Amendment Coalition, the Institute for the Advancement of the American Legal System, the Media Law Resource Center, the National Conference of Bankruptcy Judges, and the National Judicial College. So lots of important related organizations very interested in this topic. And you'll soon see why. Judge Donald, what will we be talking about today?
Good afternoon, Denise. And let me join you and add my thanks to all of those who have been with us through sessions 1 and 2, and those of you who are joining us today. And I want to thank this exemplary faculty for giving us the benefit of their wisdom, their observations, and really helping us to explore this phenomenal area. We know that most people will never get to a court, but also all people are interested in the work that courts do. They're interested in keeping up with the law as it relates to the public. They're interested in developments of the law. They're interested in how it affected their neighbor. They're interested in why this neighbor's outcome may have been different than another neighbor's outcome, notwithstanding that they may have been in two different areas of the law. But people are interested because they know that this is an integral part of who we are as a people, and certainly as a nation. In one of Dr. King's speeches, he famously said that our destinies are inextricably intertwined. And I think that is certainly true of courts and media. We need each other, we depend upon each other, and we really help each other do our jobs better. No, the press does not decide or influence judges, but getting information out to educate the public is a critical function played by that estate. In the first couple of these programs, we talked about issues, we talked about opportunities, we talked about tools to facilitate doing the job, and now we want to really get to the solutions phase and maybe maybe the solutions are a work in progress, but we're going to hopefully talk not about problems, but about opportunities that are integral to the work that we do in helping courts to educate the public through the useful means of media. And I want to start by asking Justice Krieger, what should judges do to aid the press in this process? We know that many judges are uncomfortable talking to the press. Many may say, I don't talk to media, but we now know that that is not an approach that is useful. So Judge Krieger, what should judges do to more effectively communicate with the press?
Let me start by building off of what you've said, Judge Donald. We're a country that is based in law. I always like to think of it as a brick wall, and we're all bricks of different colors and shapes, and we are held together with mortar. That is the law. And thus people should ideally understand the law and understand how courts work to administer the law. But as we said in the very first instance, most people get their information about how courts work off the internet or TV, from the press. They also get them from movies and from storylines where the courtroom scenes are used to make a dramatic statement. Very few people ever end up in a courtroom to see how a case proceeds. And so it's not surprising for folks to have some doubts and skepticism about the process because they don't know about the process. Our friends in the Fourth Estate are the folks that can tell them about the process and can reach a much broader audience than we can. And I'd like to outline a couple of different ways to think about this. The first is, what can judges and courts do to educate the public? And that concerns, what do you offer at your courthouses? Many courthouses have civics activities for kids and even for adults. Some have civic centers where you can go and learn about the court process. Others simply use their webpage to post information about pending cases and with links to other sources to get information. And Charlie will talk some about that, because the US courts have a lot of information that can be linked to aid the public and also to aid journalists. But one of the things that we have tried, and I will say we, because it's Charlie and I have done this, and also our courts in Colorado, an organization that teaches adults about the court process, have used a mechanism in conjunction with a high-profile case. The idea is that high-profile cases are those cases that the public's most interested in. And that if the journalists have a good understanding of the basics, a deep dive as to what's going on, they can help educate the public about the process. Now, we did this in two different contexts. One was in the Aurora Theater shooting case in 2012. And that was through Our Courts Colorado. And for those of you who are not aware of Our Courts, I urge you to look it up online. It's an organization that has a lot of members, but essentially is an organization where judges go out and speak to the public. We broadened our purpose when we took on the Aurora Theater shooting case. The website that you can go to is www.ourcourtscolorado.org. Now, what we did in that case is a 3-part presentation for members of the press, and they participated online as we described in the first session what the course of procedure in a criminal case was. What happened? What rules applied? Who stood where? Who asked what? All of the basics of a criminal trial. We then had attorneys discuss the legal issues. Now, note I say we and attorneys in the same sentence. We judges could not discuss the legal issues. We were limited to the procedure, and you've heard that as the ethical standard. But the attorneys could discuss two critical issues in that case, one dealing with competence and one dealing with the death penalty. They did that in another presentation. And what we found was that the vans that were parked outside the state court where the trial was taking place, the media vans, were playing the films from these presentations while reporters were in the courtroom. One of my colleagues asked the folks in the van, "What are you doing that for?" And he explained that this educated all the people who were working on the case as to what was important in the case and where to use their resources. So it helped not only on a substantive level, but for resource allocation for the press. We found that with the permission of the state judge, we were able to get information out to the press that helped the trial go smoothly. The second case, yes.
Just on that first point you made, when they asked people in the truck, "What are you doing?" Is that something you felt like you were okay with it once you learned what it was? But is that something that under normal circumstances, it would have been better for the press to get clearance from the judicial authority before setting up that, or was it okay?
I don't think so.
Okay.
Because we were careful in adhering to the ethical standards. None of the judges who participated in the presentation as to the procedure were members of the court where the case is being tried. None of those judges were in the hierarchy of courts that might consider an appeal. And we had limited ourselves just to procedure discussions, and that was appropriate under our ethical standards. We had the permission of the state court judge presiding, and indeed this helped him.
Certainly. And you were going to your second point.
The second case that we did this in was the Derek Chauvin case that took place after the death of George Floyd. At that time, I was no longer in Colorado because I'm in senior status and I now live in Minnesota. And we put on a similar boot camp for journalists prior to the trial of Derek Chauvin, who was the first officer who was tried. The state judge, Judge Cahill, gave his permission for us to do that. We were hosted by the federal district court, remember, not in the same chain, so that we could present information as to the course, the procedural course in this trial. We dealt with such things as the fact that Minnesota is a right to bail state, meaning that everybody has bail set. That's the way it works in their state court system. We had a state court judge who explained the process, as did I, before the trial took place. And similarly to our exercise in Colorado, we found that the reporting was of better quality and the journalists asked great questions, some of which we could answer and some of which we could not answer. After that, Charlie and I did a focus group with a number of journalists to find out what might be helpful to journalists. And we found, put simply, that journalists fall into two different categories. Those for whom the whole legal process is brand new and they need the basics. And those for whom, like Dan, who know the process, they don't need the basics, They need someone to itemize the elements of a claim or defense and to talk about the law that's going to apply. Now, that's not something that judges can do, but we can find people who can do that so that we are not stepping outside our ethical role.
Okay, just one more question before I go to the journalists. One of the frustrations, I believe, with journalists sometimes is they've got a job to do, they've got deadlines, and the quote high profile case, the one that everyone is interested in, might be one where also the court, for whatever reason, decides that there's too much information coming from lawyers, and then they may feel like lawyers are trying to try the case in the press, so they may impose certain gag orders that may constrain the press in doing what they would ordinarily do, and as far as talking to the lawyers. So I'm going to ask you, Judge Krieger, and then I'm going to turn to the press after this. What are some of the more familiar circumstances where judges might feel compelled to issue gag orders to control whatever, or to make certain that the defendant can get a fair trial by a jury of his or her peers?
A good example is the Derek Chauvin case. There was a gag order that was issued in that case that prohibited the attorneys from discussing the case and the parties from discussing the case with the press. But remember, in the Derek Chauvin case, it was televised. The courtroom was opened up and everybody got to see the trial. And so there wasn't probably as much concern about a gag order in that kind of context. But that's the purpose of a gag order, is to make sure that someone is not tried in the court of public opinion before they're tried in the court of law.
Great. I want to now turn to the journalists. Charlie and Dan, thank you both for being here again. And I want to ask you, what are some of the judicial practices that you believe, I won't say most frequently, but what are some of those that frustrate your ability to do the job that you have to do as the fourth estate and as our partners in educating the public about the courts? And you can, either one of you can start.
Yeah, Dan, if you could lead off on this one.
Yeah, sure, no problem. Thanks again for having me here. This is a really great discussion. So I guess I would start off again, kind of like dividing them into buckets. And the first would be the technological bucket, which is kind of the easiest, some of the easiest aspects to address. And I think I've said this in an earlier program. I do find that courts have generally gotten a lot better at this over the time that I've been covering cases. For instance, allowing laptops in the courtroom, even with internet capability, even if there's an overflow room, because I personally don't want to be dependent on overflow room simulcast. If it goes out, I'm out of luck. So I want to be inside the courtroom itself with a laptop to be able to communicate. There are still some judges who are uncomfortable with that. I think when laptops are banned within the courtroom, that makes it very, very difficult, well, basically almost impossible. And then things like providing power, things like that we've talked about in previous sessions. Beyond the technological, I would say, not making documents available, and I'll actually just focus in on one very specific one, verdict forms. It is often the case that verdict forms in a long trial are not made available on the docket or any other part of a website. And if you want one, you have to hunt down one of the lawyers on either side to try to get them to give it to you, like the final verdict form. And that document is just incredibly, incredibly important to be able to, report on the culmination of the trial accurately, particularly if we are dealing with a civil trial that might be very complicated with a lot of different kinds of claims and damage. I mean, I covered a lot of high profile business litigation, and those verdict forms are often like a flow chart. You really need to have them in front of you to be able to do it accurately. And then I would also say in kind of that same bucket, jury notes, when the jury sends out a note, and often the court might just talk, I've experienced this many times, the judge just talks about it with the lawyers and not in open court. And if it's a big trial, you've been covering the whole thing. What everyone wants to know is what's going on in the jury room. Like, where is this going? That's the biggest questions your editors are asking you. That's the biggest question on readers' minds. And often, being able to report on those notes is a very, very important part of the story. And so those are just a few examples of things that I've found frustrating in the past.
Dan, can I ask you a question?
I'm sorry, Marcia?
I was going to say, Dan, can I ask you a question?
Of course.
How often do you get copies of the jury instructions?
Well, I guess it depends on the court. I mean, generally, federal court's a little bit better because it's often just done more on the briefing. And so that tends to be on Pacer, and you can get it a little bit easier. I've had in state court, a lot of times it's a little bit more fluid in terms of how that's hashed out. I would say it's a little bit easier than the verdict form. The jury instructions, but it sometimes doesn't come. But the verdict form, I find, is more important because that really, really just, it's very clear. You can just go follow along right with everybody else, because the most high tension, intense moment is when that verdict is coming down. And if you don't have the grounding of what everyone else does, you're much more likely to make an error, which doesn't help anybody.
Okay, and Judge Krieger, did you want to address this frustration about juror notes before I go to Charlie Hall?
I can. I remember when I was first doing doing a jury trial in district court. I had all of the exhibits back in chambers because we were working on jury instructions. And I had a reporter who got very anxious and was very concerned that he didn't have access to the exhibits. And I was not as appreciative of that perspective as I should have been. And I later was. Learning from my mistake, and explained to him later that we were using them for purposes of the jury instructions. And he understood. But I think anything that goes on with the jury is of particular interest to the public. It's because juries deliberate in privacy, and because we don't know what they think. It's a curiosity. And so making sure that the public knows that there were questions asked by the jury by dealing with them in open court is helpful. I get that. And I think it's an understandable frustration when that doesn't occur.
So Charlie, back to you now on the question that I posed to Dan earlier. You had some comments, I know.
Sure.
Why don't you give us your thoughts?
Great. Thank you so much, Judge Donald. Yeah, I've actually seen this from a couple of different angles. My first exposure to state and then federal trials was as a reporter. So I really depended on navigating some of the same hurdles. The biggest of which, when you first come to a courthouse, is you really don't understand what's going on, and you can't do the thing that your fellow reporter down at the city hall can, which is to go to a press conference to hear what the mayor has to say. The judge in a case will not be giving any public statements. And so you have to start learning from people around the building. And that worked well enough in the 90s when I was covering a federal court in Northern Virginia. But the whole landscape has just changed radically in the last 15 years. There's fewer than half as many traditional newsroom reporters now as there was then. And there are very few reporters anymore assigned to cover the court. So pretty much any time you get a lot of reporters at a courthouse, you're getting a lot of people like I was in my first day in a courthouse, people who really don't know the lay of the land, don't really understand the law, but the stakes are not very high because they only come to the court when there's a big case. The second thing, and now, I work for the administrative office, the U.S. courts, but one of my specialty areas, if you will, is counseling courts that are going through high-profile cases. I helped coordinate media for the Dylan Roof case back in 2016. For the murders in the African-American church in Charleston, South Carolina. And so I've tried as best I can to try to lower some of the barriers and make it possible. But one of the things I would say the biggest mistake I see when I'm working with courts now is to really forget that oftentimes there's three parties in a major public case. You have the two that are in the courtroom are very obvious, either the prosecution and defense, or plaintiff and defense in a civil case. But in a major case, you also have a very interested public. And in the case of Dylan Roof, you had a community that was really gut punched by a horrible, horrible moment and wondering what, how the court would handle this. And so I think the biggest mistake I see courts make is that we're just treating this like any other case, and of course, inside the courtroom, that's true. You don't want to change the rules of practice and procedure, but it's not like any other case when you have 100 reporters from around the country. It's not like any other case when people around the country want to know what's happening here. And so there's a lot of things that can be done. Judge Krieger has talked about direct education programs. I think there's a lot more need for that than there was 20 years ago, because the informal training model just isn't there anymore. But also, there's a lot of ways to communicate. I think judges, far from me to advise a judge, but I think judges, oftentimes when they're writing a decision, are best to consider, is there something I need to write for the community's benefit? Some plain language way of stating what the point is here. We had a Judge Thompson last week talking about doing daily orders, sort of saying, here's what happened in court today. Those things are perfectly legal, perfectly ethical. And I will say, in the case of in the Roof case, one of the most powerful things was their really being very active in distributing exhibits. The jury by now had been selected. They were not reading what was in the media. And on a daily basis, we would actually post the exhibits of the day, oftentimes pictures, sometimes written documents, but even videos, security videos, video confession even, on the website. And in a very powerful way, it allowed the community to experience what the people in the courtroom were experiencing without coming to the courtroom physically themselves. So I think, and I would say when the verdict happened in that case, there was a strong sense that the community believed that justice had been done, that there was an acceptance of the verdict, there was an understanding of the verdict, but it really was because the process was quite transparent without in any way interfering with the integrity of the trial.
And Charlie, I would say that that's really, posting the exhibits like that, I mean, that's really a win-win, both from the public's point of view, what you just described in terms of instilling confidence in the proceeding and in the result, but also for the working reporter like me. And Judge Krieger, you alluded to this as well. Lots of times we can't get exhibits. They're still very, very difficult. And I've seen judges order both parties to create zip files and distribute them to the reporters, to the press corps at the end of the day, which is 100 times better than nothing, certainly. But what you just described of just posting them online is such a simple and elegant solution that really helps everybody.
And I might say a lot of it depends on the players involved. The judge in that case actually was the one who suggested that as the solution. But again, maybe one other cultural issue that has sort of been alluded to is many people in working courts aren't used to working with reporters, and reporters don't get that many chances to work with people, with judges directly, particularly, but other people in the courts. And so there's not a lot of informal communication, trust, or comfort when a case like this happens. So I think the judge really was to be commended for just saying, let's do it. Let's let people see what we see. And I'm not sure. I think I'll talk a little bit about what the fears are with that, but the fact that he operated in faith, it really, in essence, allowed the community to witness justice being done in a way that doesn't always happen.
So I've been on the appellate court for the last 11 years until this January, and we, while we probably like to think that we have a lot of hot button appellate arguments, I think the public probably would disagree. So we don't have some of the same issues and tension points as trial courts. Also, we now, as Dan mentioned at the outset, are in a very technological area, but some judges are still saying no recording devices in the courtroom, and no this and no that. What are some of the practices that you, Charles, well, you, Dan, run into, and that you, Charles, have heard about that really pose real obstacles to you doing your job? And what tips do you give to new reporters to deal with those kinds of issues? And I'll start with Dan first.
Yeah, I mean, I think, a couple that I mentioned, just at the most basic of not allowing the journalist to have the tools of their trade inside the courtroom. I may personally disagree about the recording policy in various courts, but like, I understand it. And at this point, I think all of us who have experience in the courts are able to deal with that particular restriction. I know a lot of reporters complain about it, but like, if we can't record, that's one thing. If we can't have a laptop with internet connectivity inside the courtroom, that pretty much finishes us in terms of being able to do our jobs in this age of lightning fast publishing. And so, my news organization, we're measured in terms of verdicts, in the fractions of the second. And just to give you an example of that, I was in Seattle when President Trump's first travel ban was struck down, and my snap lost to Bloomberg by 19 seconds, and you can see that I'm not still bothered by it at all, that I'm remembering it this many years later. But that's the world that we operate in, and so I would say that's really a big one. I know this gets into a thicket, but like, if you can't have recordings, same day transcripts would be amazing. But I know that gets into a whole other issue of court reporters and how that all works. But a lot of trial is sidebar between the judges and the attorneys, and that can be really important to understand what's happening in the trial, and the courtroom can't hear it because it has to be out of earshot of the jury. But if we had actual transcripts of what happened in those sidebars that day, that would help our coverage a lot. That's a more minor thing, but those are just a couple examples.
Charles?
Okay, well, first off, obviously, there's such a huge range of practices. I'm sure there are many people from state court systems here, and many, simply allow audio, video coverage. And at the federal level, as Judge Donald, it's sort of a circuit by circuit thing. A number of appellate courts do allow some kind of live, at least audio hearing, and as an employee of the federal courts, I probably can't comment further on the goods and the bads of that, but it's certainly allowed at the appellate level. Now, criminal trials is just absolutely forbidden. And I think that's one thing that that's just news you have to break to any reporters coming to a federal criminal, proceeding. But one thing we did and a number of courts I've worked with have done the same thing. There are a lot of in-betweens. I was really stunned. I retired, thank God, from active journalism before Twitter became a reality, because we had this very quaint system where you sat in a courtroom with this high-tech device called a notepad, and you wrote notes, and then at the end of the day, you filed the story that appeared the next morning, and so but nowadays, that's like asking a reporter to get inside a coffin and close the door for 15 hours while the rest of the world, is reporting second by second and minute by minute. It's a complete, it's a very dated way of doing things. And so one of the things we were able to do, and a number of courts have done this in federal trial courts, is essentially have a spillover room where reporters can see the same proceedings by audio and video. They're not in the courtroom. There's no concern by a judge, which I think is a legitimate concern. A witness says 2 or 3 things and nobody reacts. And then they say a 4th thing, and finally, and 17 computers are all, hit the send button simultaneously. It can distort jury perceptions as to what's important, what is not important. Similar reasons that the judge in the roof case did not allow reporters to leave the courtroom in mid session, because it sent cues as to what was important and what wasn't. And so what we did do was we had a whole separate courtroom where we had about 50 reporters with their laptops listening and watching the proceedings. And indeed, that is exactly the way it was reported. It was fascinating. 30 seconds of silence punctuated by a dozen keyboards furiously sending out the next thing. And one of the things I found fascinating about it was actually a very rich way of covering the trial. It was a mix of fact, witness statement, observation by the reporter putting it in context. You actually could follow a trial in real time that way. And then, of course, as the day, there would be breaks in the day, the reporter would bundle up their individual tweets into something like a full story. So I think actually it served the public, but by putting it in a different environment, even though there's a federal courtroom that didn't allow broadcasting, in fact, the public could follow the proceeding in real time, and the reporters were not punished for, in essence, not being able to sort of cover things the way they're covered these days.
So Charlie, have some of the innovations that courts employed in response to COVID provided some reasonable resolutions to address some of those issues?
Well, I will certainly say, and I've talked with many reporters, there's a lot of curiosity and interest in the federal courts, especially. Where will we be, when the actual, criminal proceedings now are back to the old rules, civil proceedings, there's still a discussion going on. No question, reporters absolutely loved being able to get remote access to cases. And for every obvious reason, because on top of everything else, something else we have not talked about, reporters are under time stress in a way that has no precedent. There are few reporters, as Dan said, if you get scooped by 10 seconds, it's a topic of pain, and so to be able to just be in a remote environment and see it, of course, reporters are going to love that. I think the thing that is interesting, and I think it will just simply take time for the federal court and the judicial conference, which sets policy, to resolve, is what do they believe worked during COVID that should be retained? What might have eroded traditional values and therefore, go back to some earlier model or a hybrid? But I will say, I think it showed that it could be done, because the courts, the federal courts, really depended for almost 3 years on essentially allowing people to see court proceedings in real time. And that simply was just a theory and an idea until COVID.
Okay. Judge Krieger, you and I were both state court judges and later federal court judges. And, I've emphasized the close working relationship in educating the public that exists between media and courts, but I don't want media to have to speak to the issue of what is the rationale behind the prohibition for allowing recordings. And I'm not suggesting that your court does that or did that, but there has been a question about what's the big deal? What's the rationale for the prohibition against recordings? Would you address that, please?
I will be glad to. All of the attorneys, or I should say most of the attorneys generally speaking, and the judge have an overriding concern, and that is that the process is proper. It means that the jurors follow the instructions and the attorneys follow the admonitions of the court, and this is a regular proceeding in which there is no error, so that you can trust the outcome. And what happens so often is that we are closely focused on what might interrupt that process. And that's where I think part of the fear of the media comes in. You've heard comments about journalists noting something based on testimony and quickly sending something out. If that occurs in the courtroom, the fear is that the jurors will pay attention to that particular thing and not other things, that there's some significance to that. You have an instruction that's always given to jurors that says, don't read or watch anything about this case. And when there is a lot of press coverage, it's hard for them to adhere to that. And the reason we give that instruction is because we want the jury to evaluate the evidence solely based upon what is presented in the courtroom, not what other people say about it. And I think there is a concern in addition that if you have cameras in the courtroom, you may not get the same kind of examination and cross-examination that is customary in the course of the trial that is proceeding according to a proper procedure. You may have witnesses that grandstand, or witnesses who are afraid to really tell the truth because they're being filmed. You may have witnesses who don't want their friends and family to see that they're testifying. You may have witnesses who think this is a great time to explain all kinds of things that really have nothing to do with the trial. So the idea is to keep the process pristine to the extent that you can, and everyone might draw a different line. That's why state systems and federal systems have different rules, is that they draw the lines differently.
Charlie, do you have a reaction to anything that Judge Krieger just said? And I just asked a couple of the rationales behind that, and then I'll go to Dan, and I'll switch to something else. Charles?
Well, I've seen this from different angles, and I have a greater appreciation now working within the court systems, how many legitimate anxieties there are about a mistrial in the worst case, or just some disruption or embarrassment, and simply in a smaller level concern, as Judge Krieger says. Before technology, you really didn't have much fear about the jury simply focusing on what was being presented in the courtroom. Now, literally some random moment from a trial might go viral. And so I think there are always tensions and balancing acts you need to strike to make sure the integrity of the case is preserved, while making sure your reporters have the means to disseminate accurate information about a trial of importance to the community, to the general public. And so I do believe some of the examples we've talked about show that several things can be served at the same time. This idea perhaps of reporters in a separate room being allowed to tweet their way to deadline writing allows allows the public to be informed while keeping them out of the courtroom itself. There typically, I believe, are actions that can be taken that really, again, remember that the public has a stake in these types of cases. And it usually takes some willingness to look beyond just, we're going to treat this like any other trial. It does take a little extra thinking and imagination to solve these types of problems.
Dan?
It's interesting, as Judge Krieger and we're talking, and Charlie, you're talking about, the phenomenon of reporters clacking out, typing on some parts of testimony and not on others, and how that might influence the jury. I never thought about that. And probably because I'm one of the ones doing the clacking. And it really makes sense. I mean, it's, I think, inarguable that if I were a juror, I would be wondering more about that part of it. And so I think all of this really argues, again, for the importance of open communication and transparency between the judge and the reporters who are there, and the judge is saying, hey, listen, the reason why I'm thinking about doing this or that is because I am concerned about X, Y, and Z. And then the reporter saying, fair, and that creates this issue. Can we address this issue? Boom, done. Right. So I think to the extent that it can be viewed as a collaboration in good faith between both sides, and with that open communication, most of these issues, I can imagine, are dealt with easily.
And if I may circle back on
Yes.
that actually is something which happens a lot in a high profile trial. And I think it's something I strongly commend, which is essentially pulling together essentially an informal reporters advisory committee to talk with the courts while you're still in the stage of putting rules together. Because again, when you really start learning what each side needs, what their genuine reactions are to the other side's requests, usually there are middle grounds, and it simply builds trust. We did that in Charleston, but I see that happen fairly regularly, and it's an off-camera dialogue, but it's very important. And sometimes it's really the first chance for many of the reporters and many of the people on the court side to really get to know each other in a problem-solving context, and it usually pays quite large dividends, as Dan's describing.
Okay, I'm going to ask one other question, and it's going to harken back to an area we talked about before. And then I'm going to get, your wisdom for new and experienced reporters and wisdom for new judges. But we talked about high profile trials, and oftentimes high profile trials have additional issues that make them higher profile. You mentioned Dylan Ruth. Judge Krieger mentioned the Chauvin trial in Minneapolis. And many of these cases have overarching racial issues and racial tones. And so I want to ask you, Dan and Charles, what is the obligation, if any, of the press in those issues to try to make sure that you somehow lower the barometer on the racial part of it, even if that is a central component? And I know these can become really difficult when you have the race issue or the political issue. We talked a little bit earlier about identifying the judges as a judge appointed by a Republican president or a judge appointed by a Democratic president. And on the state side, there are other issues. But is there any obligation? And if so, I mean, what can be done in those cases to report the issues, and just the issues, if you will, to help in some way lower the temperature or lower the barometers on those? And whatever your answer is, it is. I'm just thinking. So who wants to start? Dan, are you clicking off, or Charles?
I'm actually willing to take a first shot at this.
Okay.
Because I actually think that is what a court doing its job does. You know, when
Okay.
I went down to South Carolina the first day, I was meeting with all kinds of court staff. At one point, I was talking with a lot of the people in the clerk of court's office, and the fear and the anxiety was palpable. It was almost like, oh my God, we're about to be invaded by reporters. What are we going to do? And after about 10, 12 minutes, I was feeling even my own anxiety going up, and it just felt unhealthy. And I paused for a minute and I said, this whole community has been wounded by this event. We've been focusing a lot on the fear and the negative, but this is an opportunity to demonstrate that justice can be done even in the worst moments. And you could almost see people start to relax, and they realize that's what we do. We do justice in this building, no matter who has been killed. Because on the one hand, a high-profile trial is not business as usual, but in the end, that trial is about a specific crime that could happen in any context. Dylan Roof was in there because he murdered 9 people. 9 people, doing Bible study. And the evidence that had to be presented was the kind of evidence that had to be presented in any case. And what happened was the public would not even know that 99 cases out of 100 in the District of South Carolina were happening. They were there paying attention to this one. And by simply doing business at a very high caliber, but allowing the public to see it, helping the reporters to communicate the process, I actually believe one of the reasons the verdict was accepted was because there was a high level of transparency. And people didn't just trust that the Dylan Roof case was handled well. They came away trusting that that court handles all cases well. And I believe the reporters communicated some of that trust because we were communicating with them beforehand. There was openness. What are your needs? How can we help you do your job? And in the end, I have to tell you, the single most striking thing about that experience for me was all the anxiety in the beginning. By about 2/3 of the way through the trial, there was like such harmony among many people doing very different jobs. Yes, the judge doing his job, the reporters doing their job. But the people at the metal detector line, the court security officers, the Federal Protective Service officers out on the grounds, the camera people doing their stand-ups outside. It was like everybody was doing their job, but everybody created space to do their piece of it. And there was actually a tremendous sense of goodwill all around, not just with the public, although I think that was true, but the reporters came away with a tremendous sense of goodwill to the court. And interestingly enough, the court had to handle another high-profile case 4 months later, and they did it with a completely different environment because of what they've been through. So I mainly would say it's an opportunity. Do what you do best, let people see it, but in this particular case, make sure the reporters can do their job. And in my experience, generally the result is pretty positive.
Judge Donald, could I
It's
jump on
wonderful. It's
Charlie's
wonderful to
bandwagon?
know. Excuse me, Judge. It's really wonderful to know and to hear that sometimes the things that we can do, the procedures we have in place, really can help us experience justice. So, Justice Krieger.
I want to jump on Charlie's bandwagon a little bit here and add something to it. One of the things that I think reporters do really well and can do to aid understanding of the process is to accurately describe it. To be able to say the elements of this charge are A, B, C, and for the defendant to be convicted, a jury must find beyond a reasonable doubt that these have been proven. And that's in a criminal case, and obviously in a civil case with another standard of proof. But to be able to say to the reading public or the watching public, this is what our process is about. It's not about who wears what in the courtroom. It's not about who has fancy arguments and who has the most attorneys. It's really about what happens in that process that allows juries to make a decision. And I am so pleased when I see that in an article or on TV, because I think what it says is we all share a belief that that's a good process.
Dan?
Yeah, I mean, it's a really excellent question that you asked, and it's a very, very difficult one to answer from the reporting from my perspective. And I'm not sure I'm going to even really be able to answer it, but I'll make a few observations. I mean, I think in terms of, I mean, the way, as you put it, lowering the temperature. I mean, I think the best journalism is journalism that contains context and nuance. And in terms, and that is often in conflict with speed and the speed at which we are expected to operate at this moment in time. And those are often casualties of speed. And so do not serve readers or the community well. And so I think one antidote to that from our perspective is that we need to be really prepared. We need to do our homework coming in, and to be thoughtful and have conversations with our editors and with each other going into the proceeding, so that we are able to instill our reporting with context and nuance, which can, help present the facts most accurately. And then, I mean, the other observation I'll make is I'm not actually sure all the time that it is our job to necessarily lower the temperature. I mean, if the facts are what the facts are, I think we need to treat our readers like adults and present those facts. And that might be taken any number of ways, and we can't always control how those facts are digested. Maybe they're not as explosive as we would have imagined, and maybe something that we don't think is that incendiary becomes so. And so I think really, if we can just report again with as much forethought and nuance as we can, then that's what we can do, and the chips kind of have to fall where they may.
And I think what I hope you're saying as a part of that is that in that reporting, it would be balanced and not reported in a way to promote this incendiary effect that we're talking about, because we know that can happen. And I certainly don't believe anybody who would do that. I know we only have a little bit of time left. So I had a question about your message to the new reporter, whatever. But before we get into that, I want to take a few audience questions from the chat. And then right before Judge Fogel comes, I'll come back to each of you for your thoughtful comments and tips to the new reporter and the intermediate reporter, etc. But Denise, you've been monitoring the chat. Are there questions that we have for our panelists from the chat? And if so, would you ask those and direct them as appropriate?
Oh, thank you so much, Judge Donald. And thank you for this fascinating conversation. We have a state court judge who says, what if in a family case, the lawyers and the family ask for the proceedings to be closed? Or there are different considerations? And I'll turn to Judge Krieger.
That's a difficult one, and it's a good question. The public has a right to know. And I would say it's easier to resolve that question in a commercial case, a civil case that involves commercial issues, because you simply say the parties chose the court's public, and so therefore everybody gets to know and hear and see what's going on. Sometimes when you're in a family law situation, however, there are sensitive issues. Sometimes judges take children, for instance, who are going to testify and have them testify back in chambers where no one can hear them in order to protect children. And I think you have to go through that balancing test of the right of the public to know versus the harm that could be caused by doing this in a public arena. because of course, family court issues can't be resolved necessarily outside the court system. There's not an arbitration option available for them.
Thank you. And Dan, I'll turn to you for the next question. How do you move the needle a little bit with a court? How do journalists identify to the court sort of, these are my issues, these are my concerns, how can we work together to fix those?
Yeah, it's a good question. I mean, I think specificity and, starting off again with a presumption of good faith, and being respectful and expecting that you're going to be, treated that way, being thoughtful, and often that will help. And then, if it's not being addressed, then you need to be a bit of a pain and be persistent. Again, respectfully, but not letting it go until you get an answer one way or another. Either, yes, we can do that for you, or, we can't do this, but this is why, and let's try to figure out something else.
Thank you. And then I'm going to sort of read this question as I go, so forgive me. And this, I think, will be the last question. We've talked a lot in these sessions about how to educate reporters. What can judges and staff on the front lines of access to proceedings and records and requests, what do they need in terms of support and resources to feel more educated on the First Amendment and common law rights of access, various state laws, rules? This is a big question regarding public access, so that judges can do the important work of monitoring for litigants' excessive sealing requests for overly broad gag orders. That's a huge question. But Judge Donald, I'll unfairly turn to you, as I often do. What are the best ways to guarantee public access?
Well, I believe that many courts have informational documents, how the courts work. They will have some information on basic educational materials. I think using that information, if we're talking about the public and if we're talking about beginning reporters, if there is a public information officer, clerks of court, not law clerks, but the clerk of court may have an informational channel to help people get information on these types of things. And don't forget that a lot of information on basic legal issues is available at the public library, on foundational documents that people may use. So I think you can use things like that to get that information. But from the reporter standpoint, don't ever be shy about looking at the public pleadings. And then when you get things in there, go back and doing a little bit deeper dive. Those kinds of things are helpful. I mentioned once in one of the earlier sessions, one of the most effective techniques that I observed when I was on the bankruptcy court, and we had a complex commercial case coming up that it was of high public interest. The judge, in order to make certain that the reporters could do their job, brought the lawyers and the reporters in. They were introduced to each other. The lawyers had an opportunity to explain just common definitional terms along with the judge. And then they by agreement, put together a tutorial that helped the reporters, but also that tutorial was available by consent. When there were certain issues that came up, the lawyers could stipulate that the definition from the tutorial could be provided to the jury. This did not in any way supplant the factual witnesses, but I think we have to be innovative and creative and meet the need of educating the public and educating the triers of fact, because we spend years in law school learning this stuff, and people are asked, come together, make critical decisions, and don't talk about it while the process is going on, and don't look at any external sources, but at the end, make the right decision based on the evidence that's in the record. So it's a tough task.
And yet you were up to it. So will you forgive me if we turn briefly to Judge Fogel's video?
I would certainly invite you to do that. And I want to tell people, when we come back with Judge Fogel's video, I want you to give your parting 30-second words of wisdom to judges and reporters. Go, Denise.
I love that. Justin, can you go ahead and show the video?
Good afternoon, everyone. I want to start by saying how sorry I am that I can't be with you for this last session. I had an unavoidable conflict that came up after we planned the program, but I feel immensely confident that what you've heard prior to my giving you this recorded message now has been just as strong and useful as the other two sessions were. I want to thank all of the people who made this possible. It really was a team effort that involved a lot of people. I want to start with my colleagues, Justin Doe and Denise Neary. They did the heavy lifting to make these programs come together. They did the technical support. They did all of the planning that was necessary to get these webinars online, get everybody registered. Denise did just a tremendous service in getting all of our co-sponsors to join the program and bring in people from a variety of different constituencies. Really a lot of work goes on behind the scenes to make these programs happen. And I want to really give a big shout out to my colleagues, Justin and Denise. I also want to thank our co-sponsors. They're too numerous to name, but they represent a very wide swath of the world that we're part of here, judicial organizations, legal organizations. And I think it reflects the recognition that relationships between judges and journalists are really important, and that there's a lot of work to be done there. That, as I said in the first session, we're all involved in the same basic project, which is to get the truth out, to get the evidence before people so that they can make evidence-based and informed decisions. And we, although we have different jobs and there are some ethical constraints we need to work with, we really ought to be pulling together to the extent that we can. And to make that happen requires communication. It requires understanding between the two professions as to what each of them has to do, what the constraints are that each of them deals with, where cooperation works, where it doesn't. And I think what we've tried to do in these sessions is to get granular about that, to really talk about it in specific ways that are helpful to judges who have to deal with journalists and vice versa. And I hope that we will continue this. There's a lot of follow-on work, a lot of relationship building that needs to happen and can happen. I want to give great gratitude to the panel, the people who joined us. And I want to make a special point of thanking Judge Marcia Krieger. She was the one who put together the original program in Tucson for the Ninth Circuit Midwinter Workshop that was the inspiration for this program. She's done remarkable work in Minnesota, in Colorado, around the country in raising the awareness that good communication between judges and journalists is important for people understanding the way our legal system works. It's a very important civics lesson. We can't get the word out without judges talking to journalists and through journalists talking to the public. And we can't get the word out without journalists reflecting that back to their audiences. And Judge Krieger has been much involved in the leadership of making that happen. I want to give her a special thanks for giving us the germ of the idea that led to these programs. Also, the other members of our panel, Charlie Hall from the Administrative Office of the Courts, who was involved in the original program that Judge Krieger organized. And Charlie has the benefit of being both an inside person at the AO and also a journalist, somebody who's worked on both sides of the street and really has an understanding of what's involved there. And I think he provided tremendous value in his contributions to this program. I want to thank Dan Levine. We talked last week about our long relationship, professional relationship as a judge and a journalist who got to know each other and cooperate with each other in appropriate ways, ethically appropriate ways over the years. Dan is a really excellent journalist, great track record of working on stories involving the courts and helping people understand how the courts function. Done a lot of work in particular on unsealing of records and public accountability in cases involving some really significant serious conditions. And I want to thank Judge Trina Thompson, who joined us by video last week. She was unable to participate live in the program. She was part of the program in Tucson. And you could see even in the short segment that she did, that she has really unique hands-on experience in handling high profile, high controversy, major cases in her community, and figuring out a way to do that in a way that is inclusive of the media and also consistent with the canons of judicial conduct. And last, but certainly not least, in our faculty, I want to express my great gratitude to Judge Bernice Donald. We've been friends and colleagues for a very long time. I think you've got a sense from her participation throughout this program, just how much wisdom she has, how much relevant experience she has, how thoughtful she is about all of the issues we've talked about. And I want to say that I'm especially thankful because she joined us late. We really thought she could add something that we were missing, and we were not disappointed. She went out of her way to be part of this program. So Bernice, thank you so much for doing that. And I think that's the big message we're trying to get out here, is that you can talk. If you're a judge, you can talk to the press. There are ways you can do that are totally ethical. They're totally permitted by the canons. And in fact, they're even encouraged in some respects by the canons if you're not talking about the merits of cases, if your point is to educate the public. And really sort of trying to emphasize how valuable judicial participation and input and being part of this education project can be for not only journalists, but for the people who read and hear what journalists produce. And I think the program also has been helpful because it helps the people who cover the courts to understand as well as they can and as fully as they can the constraints that judges are under, the way that things work. What is a temporary restraining order? What is a preliminary injunction? What is the meaning of a seal in a discovery order? These are all things that are not intuitive if you're a journalist. You may know about them if you're a judge, but just having that kind of communication is really helpful in making sure that the stories that come out are accurate and informative and tell people what's really going on. And that is part of this enterprise of getting evidence and truth out that I think is really critical. And I think those are the things that I wanted to say, is that we, the judiciary, need to figure out ways to get our story out. This is how you begin to build public trust and accountability beyond the levels that it's at now. Well, that's it. Thank you for joining us. And I really, really appreciate everyone's time and participation. We got great questions in the chat, and good luck and farewell to everyone.
Well, but then I will, we could still do 15 seconds each. How's that?
Okay, 15 seconds. Any kind of best practice or tip you want to give, Judge Krieger?
I want to say thank you. I enjoyed being on this panel and working with all these folks. They're fabulous. And I want to extend an offer. If there's anybody in the audience who wants more information about how to go about this, feel free to get a hold of Denise Neary, and she knows where to find me.
Thank you. Charlie Hall.
First off, huge thanks to you, Judge Donald, and to BJI for hosting these programs. They've been fantastic. I think there's clearly tremendous mutual interest and need. If I had two things I would like to see, one is greater training, so more courts and more judges feel comfortable and confident in this kind of dialogue. And secondly, I do believe because of the modern era, there's more need than ever to really provide educational opportunities to the media. I think only good can come from working together in these areas.
Thank you, Dan Levine.
Thank you very much for doing this and for having a media person to be in the mix here. I guess I would just say, in terms of advice for judges, I would say, and this is not to be glib, but follow the law. You know, the case law is really, really outstanding on open access to the courts. It's really evolved in an incredibly good way. What we just really need is for judges to be aware of that law and to implement it. And I think training could be a great way to do it, but, you know, just follow the law that we have.
And I would just say, in this noble task of educating the public about the law, remember that our destinies really are inextricably intertwined. And with that, take us out, Denise.
I will say, Judge Donald, any program that starts and ends with Martin Luther King is a program that I will adore. I'm so grateful to all of you. I'm so grateful to all the participants. I will anonymize the chat, put something up there. Thank you, thank you, thank you. Judge Krieger was not just being polite when she made her wonderful offer. So please follow up with me if it's of interest. Thanks to all our co-sponsors. Thanks to all of you. Special thanks to Justin, who basically put this program together with Dixie cups and string. So that's what I'm grateful. Have a great weekend, everyone. Thank you.